So welcome to our webinar. We are happy for all of you to join us. Again, I'm Mindy Knutson, the Executive Director for CAI Utah, and we have a great presentation for you today. We'll give you a couple of announcements on upcoming things. Our next webinar is November 13th, and that will be on CC&Rs and state statutes. Today, our presentation is COVID-19 Association Liability and Cleaning Tips with an HOA case law and legislative update for 2020. We'd like to thank our sponsors. Our diamond sponsors this year are Advanced Community Services and also FCS Community Management. And we'd also like to give a big thank you to our exhibit sponsor, which is SunWest Bank. And SunWest Bank, if you're looking for a bank that genuinely understands the HOA and property management industry inside and out, look no further than SunWest Bank. With over 40 years in the HOA lending space, we have products and services specifically designed to meet your community association's needs, including a variety of time and money saving options. Our Utah-based HOA banking team can work with you not only to pick cash management solutions that cover your complicated transaction and payment needs, but we can also help you secure financing for things like property renovations and short-term cash flow needs. Visit sunwestbank.com/HOA to learn more or call Chad Cantor at 801-699-1835. And so thank you, SunWest Bank. And with that, we will turn our time over to our moderator, Neil Schiffman, to announce our panelists and our program.
Welcome to our webinar this morning. We're going to have three presenters today. Scott Evans, who's the Vice President of RBN Building Services. Scott is engaged in facility services industry, having served as a national and international trainer for different operating systems in varied local, regional, and national executive leadership positions over the span of 30 years in the industry. He has been a leader and member of core development teams for specialized operating systems spanning 3 decades during these years. We'll also be joined by Tyler Lamar. He's an attorney for Miller Harrison. Tyler is partner and a founding member of Miller Harrison. Tyler handles HOA matters, FHA certifications, governing document drafting and amendments, rule enforcement, collections, real estate development, insurance litigation, and insurance coverage, landlord, tenant, small business associations, contracts, HOA setup and development, and general litigation. Quinn Sperry is an attorney for Jenkins Bagley PLLC. Quinn is a partner with Jenkins Bagley. His practice includes all aspects of community association law, including governance issues, governing documents, litigation, and general counsel. He's a Utah Business Magazine and Super Lawyers Magazine. They've both recognized Quinn multiple times, respectively, as one of Utah's legal elite and a super lawyer. So we'll go ahead and get started with Scott.
Thank you, Neil. Appreciate it. Good morning, everyone. I don't know that I can think of anything more riveting than to talk about law and cleaning and do it together. So I'm honored to be here. I look forward to it. We were on, or I was on a training yesterday for about an hour, and we talked about some important things. But one of the things that was taught to us and emphasized over and over, and it fits really well with this COVID season that we're living in. And that was, it was about focus. It was about being present, but what they taught us was about just win the day. What happened yesterday happened yesterday. What happens tomorrow is going to happen tomorrow, but what happens today, just win the day. And that's what we're going to talk about a little bit here with our cleaning tips. And anyone that's paid any attention at all over the past several months, we know that in the COVID world, everything has changed, sometimes hour by hour, certainly day by day, month by month, and all the information's come at us rapid fire. Some of the things that have stayed pretty consistent and pretty constant have to do with cleaning and how do we attack the virus itself from a cleaning standpoint that gives us the best opportunities for health. And that's what we're going to talk about today. We're going to 4 or 5 slides, and we're just going to talk about how do we give all of us the best opportunities for good health during this season of COVID-19 and coronavirus. All right, it's not moving the slide, so can we change it to the next one? Thank you. I want to focus on these 2 points, and whether we have any commercial space or our own homes, these 2 things are the most important things that we need to know and understand about cleaning anytime we're talking about disinfection, but especially when we're talking about cleaning in a time with a pandemic and specifically with COVID-19. And I've bolded complete disinfection and I've bolded dwell and contact time. I want to talk about both of those for just a minute. Whenever we clean and disinfect for the purpose of getting rid of bacteria, germs, in this case a virus, our only goal, our only objective should always be complete disinfection. And we're going to talk about what that means in just a minute. But as we clean at home, as we clean in our commercial spaces, as RBM cleans in, many commercial spaces with multi-millions of square feet, our only objective is complete disinfection when we're dealing with COVID-19. How do we get it? There's only one way you really get complete disinfection, and that is with, and they call it dwell time in our industry or contact time. And if you go ahead and flip that for me, please. What we mean, and this is really, really important about what dwell time and contact time means, and it's really important at home as well. And at home, it's when it's the hardest to do this. Just when we're cleaning at home, we're often in a hurry, and we're trying to get through so we can move on to the rest of our activities. We have to really pay attention to this in the commercial cleaning as well. But in order to get complete disinfection, whatever surface you're disinfecting has to stay wet. You see that highlighted in yellow, bolded and highlighted in yellow. It has to stay wet for whatever amount of time it is that product says it has to stay wet to give complete disinfection. In the industry, we call that dwell time. Many people call it contact time. It's so very important for everybody on this call, on this webinar, to understand that when we're disinfecting for COVID-19, we want complete disinfection for health. How do we do that? We have to keep the surface wet for whatever amount of time it is that product says we need to keep it wet for. That's dwell time, that's contact time, and it's really, really important to give us that complete disinfection. So if you could change it for me, please. I've listed on here some of the more popular, and it's kind of small, but I've listed on here some of the more popular products that we use out there a little bit in the field, but also at home, and what their specific dwell times are. So, for example, the top one, Lysol disinfectant spray. That's a very common one that people have in their home. It's a common one that we see in a lot of places. Maybe some of you know, maybe many of you don't. It is important, critical, and mandatory, really, that we keep the surface wet for 3 minutes. 3 minutes when we are disinfecting our homes, our doorknobs, or whatever we're doing with the Lysol disinfectant spray. And you can kind of go down through the list. It talks about some wipes. It talks about some other sprays. So it doesn't matter if you're using a spray and a towel that you have at home. It doesn't matter if you have an already prepared wipe. The dwell time that you do in that particular circumstance is the same. And on the product itself, somewhere on the label, somewhere in the instructions, it will tell you the contact time or dwell time that's required for whatever product it is that you're using to disinfect for coronavirus and COVID-19. If you can't find it on the label, if you can't find it in the instructions somewhere, you can always go to the internet and look it up, which is what I did for this slide. So I Googled dwell times for disinfectants for COVID-19. This is one of the pieces of information that I found. And so I just pulled it straight off and put it in the slide here. It took me 2 or 3 minutes is all to find that information. So that's available to anybody and everybody. Just please understand, if you haven't been, today going forward, anytime you're cleaning and disinfecting for COVID-19, keep it wet for the exact amount of time that it says to keep it wet for, based on the label and the product you're using. Really important. Thanks. Go ahead and move the slide, please. When we talk about cleaning and disinfecting for this pandemic, we always want to focus on the highest of touch points. And this doesn't matter, again, if it's in an office building, if it's in our home. You'll see I have some pictures of our car, any of those things. Where we touch the most often are the places that we need to disinfect the most often. Okay, the parallel there. The places that we touch the most often are the places we need to disinfect the most often. And I just have a sample of those different kinds of surfaces, whether it's a refrigerator or a doorknob or a sink or the door going into an office building, the steering wheel of our car, where we shift in our car, the computer mouse that we use, the remote, any of those types of things. You can just think about your own life, think about your own activities, think about those places that you touch or your family touches most often. Those are the places that need to be disinfected most often. And the more often we do it, the better chance we give for continued health as we travel through this time of a pandemic. So focus on the high touch points of your home, focus on the high touch points of your car, focus on the high touch points of where you work. All of those things give you the best opportunity to stay safe, to stay healthy through this time of a pandemic. Okay, go ahead and switch it. We're going to focus on the 6 steps that the CDC and EPA together teach us and give us for, again, giving us, our whole goal here is to have complete disinfection, giving us the best opportunity to stay healthy during this time of COVID-19. Number 1, pay attention to whether your product that you use is registered and approved by the EPA. Every product, if it is, will have a registration number on the label. It'll say EPA registration number. It'll give the number on the label. That tells you that it's been approved by the EPA for the purpose of disinfecting germs, bacteria, and virus, and specifically for COVID-19 in this time. Number 2 is read the directions and follow the directions. And I put 5 words here that are very important. When we're talking about disinfecting, when we're talking about getting complete disinfection, follow the directions, and almost always more is not better. Okay? So we don't want to mix it up stronger. We don't want to do any of those things that alter how it's already chemically built, because it's chemically built to give complete disinfection based on the dwell time that it tells us. And that's really important. So make sure it's registered by the EPA. Make sure you follow the directions exactly, because that will give you the complete kill with the exact amount of dwell time that we have. Number 3, if the surface is dirty, so if it's a desk at home, if it's a countertop at home, if it's a desk in the office, and it happens to be dirty, the CDC tells us to clean the surface first with just a normal cleaner of any kind, and then disinfect and allow the surface to stay wet for the amount of time that the product tells us we need to have the dwell time. Okay, number 4 is to follow exactly that dwell time that it tells you. If it says 2 minutes, make sure it stays wet for 2 minutes. That means you have to keep spraying the surface. If you see it start to wick off and dry off, spray it again. If you're using a wipe, wipe it again. If you're seeing it start to dry, keep all the surface wet during that time of contact so that you get complete disinfection and complete kill of the bacteria and the virus. Always wear gloves. Okay, we want to protect ourselves. It's always most important to protect ourselves first, and then we take care of whatever it is that we're taking care of, is whatever we're disinfecting. So wear gloves. If they're disposable gloves, throw them away after you've disinfected. If they're reusable gloves, you can wash the reusable gloves. You can even spray the reusable gloves and disinfect them, set them aside and let them dry. And then every single time after you take your gloves off, wash your hands. And as we know from what we've been taught over the last several months, it's important to use warm soapy water for a period of 20 seconds to give our hands a good cleaning and a good wash. And then always a reminder to keep any of the disinfectants that we use safe, lids secure, out of the reach of children so it remains safe. So just a quick highlight again, please remember contact time and dwell time is most important when we're talking about complete kill. Follow the directions, protect yourselves, always glove up, and let's stay safe out there in this time of COVID. I think that was the last slide. Is there any more? Okay. I thank you for the opportunity to share a few minutes. What we talked about are recommendations from the CDC, exactly as they recommend it, exactly as the approvals come from the EPA, all of which give us the best chance, and I want to reemphasize that again. It gives each one of us individually and our families the best chance to stay healthy and to stay strong during this time of a pandemic and COVID-19. So I look forward to any questions and opportunities. Neil, we'll turn it back over to you, and thank you for a few minutes of time.
Great, thank you, Scott. Thank you for that information. I had no idea about that dwell time thing. I'm gonna have to change my cleaning regimen at home for sure. All right, Tyler and Quinn, we'll go ahead and move over to you for the legislative update and kind of the bookend for the awesome COVID year of 2020.
Thanks, Neil. I'm going to start out with just a few comments on some risk management. And also, Scott, thank you for that. I learned some information as well on that contact time. So that's important to know. First thing to start out with is, I'm sure many of us over the last few months have looked at the question of what authority does the board have to close common areas, especially as we're looking at clubhouses and pools, although pools are now, for the most part, done for the season unless you have an indoor one. And so what you're doing is looking at your governing documents, either in your CC&Rs or in your bylaws, for the duty that the management company or the board of trustees has to operate the project, and specifically to promote the health, safety, and welfare of the owners and the residents, and also responsibility to oversee, manage, and maintain the common areas and facilities. So different associations' documents will word this differently, have them in different spots, but you want to be looking for some general language that gives that broad authority to the governing body of the association to manage the project, especially for health, safety, and welfare of the residents and owners. Once they have that authority, well, another thing that they have is going to be their rulemaking authority. So that's afforded to the governing body by statute, also typically in the governing documents. And so they can adopt rules specifically regarding these common areas during this pandemic. Good point of advice is always incorporating the guidelines that we have in place by the local health department and by the local municipality. We know that those have been changing over the last few months, and so boards may need to be updating their rules quite frequently to incorporate those new guidelines, unless you want to have a catch-all of just that every resident and owner must be following those local guidelines. And then also fiscal responsibility. So the board, they have the responsibility to manage the funds of the association and to look after the financial interests of the association. which brings us into the next slide, which goes into liability insurance. You guys can advance that. And I know I saw Lamond is one of the participants today. I don't know if we have some other insurance professionals, so feel free to chime in if you want to. Oh, you went one slide too many. Go back one. We want the slide that says general liability insurance.
As we're getting these slides pulled back up, just a reminder, if you do have any questions, go ahead and type those in the question box. And if Quinn or Tyler don't answer them just in their presentations, we'll circle back and make sure those questions are answered.
Okay, the impact of the association's exposure impacts their financial responsibility and the costs that the association could be facing if they were to open up the common areas. Not only additional cleaning expenses, but also if somebody were to contract COVID or some other virus and wanted to bring a claim. Now, we'll be talking about some protections that the association has here in just a moment, but as we all know, that doesn't, just because you can prevail on a claim doesn't stop somebody from bringing the claim. So if somebody does bring a claim against the association for being exposed to or contracting COVID-19, you're going to look at the potential of tendering that to the association's insurance carrier. And the insurance policies that I've reviewed for clients, they exclude these communicable diseases or viruses. And so the information that I have on the screen there is some actual language taken from a couple different policies of clients that I've looked at. And like I said, Lamond or some of the others, you've looked at a lot more of these, you've probably seen similar provisions. So with the communicable disease, that's going to be COVID-19. And so anybody who is contracting this disease and bringing a claim against the association, there's not going to be insurance coverage if your HOA's insurance policy has this exclusion. Some of them also have a virus or bacteria. Again, it's going to be excluded. So what that means is if the association is opening up its common areas or it's open and they're not taking the right precautions, they could face a claim being brought, and they're not going to have insurance coverage for that, which means the association is going to have to pay all of the expenses of that defense. Even if the association prevails, then you're looking at, well, can we recover against the owner? In Utah, you can only get your attorney's fees if it's allowed by contract or by statute. Most CC&Rs are not going to have coverage for this type of claim as a tort claim, and the statute's not allowing for it either. So you're not going to be, most likely not going to be able to recover your attorney's fees that you incur in defending it. So that is another important thing to keep in mind for boards, is if you're opening it up, that there is some exposure. And so then it becomes to what protections are in place. Go back one slide. So we do have the benefit that our state legislature in a special session adopted a COVID immunity statute. Now that doesn't give blanket immunity to associations, as some of us have attorneys, and I think some managers have probably heard that there's this rumor out there that given this statute that we're completely immune, nobody can bring a claim against the HOA. That's not true. So let's look at some of the aspects of this statute. First of all, the statute does define person. It relates back to another statute, and community associations do fall within the scope of that term of person. So we know this is going to apply to HOAs and community associations. The statute also provides immunity from civil liability for damages arising from or resulting from the exposure of an individual who is exposed to or even contracts COVID-19 on the premises that's owned or operated by the person or the community association. So that is a good is a good provision for associations. You know, you can take some comfort in that we do have some level of immunity, but it's not a blanket immunity. So there are some exclusions, and the statute outlines those. That's willful misconduct, reckless infliction of harm, or intentional infliction of harm. So those are higher standards than just ordinary negligence. The association is going to have to really look at, if we have some procedures in place and we're following those, then it's going to be very difficult for somebody to bring a claim and assert that what the HOA did was willful misconduct, reckless infliction of harm, or intentional infliction of harm. So what are some of the precautions that we can be taking? First of all is the signage. We've all seen the signage that we have around in different businesses about keeping social distancing, about wearing masks, cleaning, hygiene. Have that signage there, especially on clubhouses and different common areas. Have a separate sign about that, as well as people are using it, that they're assuming some risk and that they are aware of those risks of using that common area and facility. Adopt your rules. We talked about that just a moment ago. Adopting the rules to incorporate some of the guidelines from the local health department, from the municipality, and again, those are requiring the social distancing, wearing masks, frequent cleaning, and other rules that are going to be particular to your association and the specific common area that you have. You can adopt rules. Something I like from Scott's presentation. If you're going to be requiring owners to be cleaning certain items, like if you have a fitness center and you're going to be allowing people to use that, but you also require them to clean it both before and after, put something in there about that contact time or the dwell time that Scott just talked about. So if they're using certain cleaning time or cleaning materials, that they have to allow it to sit on there for that time that Scott outlined to make sure that it's being disinfected. The other reason it's important to adopt these rules and incorporate the guidelines from the health department and municipality is, if you don't bring it into your rules, what enforcement do you really have? So we know that if somebody violates a governing provision, we want to be able to warn them and then levy fines against them to try to bring their actions into compliance. And so by adopting the rules, you're ensuring that you can take those enforcement procedures if somebody is violating it. Social distancing, again, we've talked about that. Hopefully by this time, all of us know what that means. And keeping 6 feet at a pool or other areas, you can actually mark off areas to keep that distance so it's easy for people to recognize. Increase cleaning and disinfecting. I think Scott covered that very well. And I think a good tip for associations is, depending on your certain common areas, bring in a third party that does this and ask them, what type of cleaning regimen do we need to have for this specific common area? And then they can either do it as a third party, or you're requiring owners to clean both before and after that they use those areas. But that way you're getting some information from a professional of what needs to be done for that specific common area, and then incorporate that into your rules and into your cleaning regimen. Exculpatory agreements. So these, the most common one that people see are waiver agreements. And so this is something, if people are going to be using those common areas and facilities, that they're agreeing to waive a claim that they can bring against the association if they're exposed to or contract COVID-19. The important thing to keep in mind here is Utah law has stated that you can only waive claims for ordinary negligence. So that's going to be the same coverage that we have under the statute. So then the question is, why would we even want to have these agreements? It really comes into play when you can incorporate some indemnification, where if somebody else, if one of their guests brings a claim and they bring it, and again, it's really only ordinary negligence, so the association can prevail on that. This then gives the association an avenue to recover its defense costs by going against that owner who agreed to indemnify the association as part of that agreement. It also will act as an assumption of risk in having people acknowledge in writing that they're aware of these risks and they're still going to go forward and participate and use these common areas. The association can use that as part of their defense in showing that these people assume some of the risk, that they're comparatively negligent in the actions that they did in using the common areas. Finally, another precaution to take is the association can look at adopting a policy for notifying residents if someone in the project contracts COVID-19. So an important thing is you don't want to be disclosing the identity of these individuals unless they specifically state that you can. But the policy is really intended that if you know that somebody has it in your project, that you're sending out notice as a reminder of residents to take extra precautions, to be cleaning, to be washing their hands, wearing a mask, to ensure that that is not spreading. It's you're not trying to shame or ostracize anybody specifically, but again, it's to build awareness and remind people of the steps that they need to be taking to be safe. So with that, we'll go to Tyler about some drafting considerations to help with some of these other issues. So go ahead, Tyler.
Thanks, Gwen. Hey, good morning, everybody. I want to try to be quick on these drafting considerations just because I want to save more time for our legislative update and case law update. We did have some action up at the legislature, and we had more than usual cases reported by our Court of Appeals and Supreme Court. So that's always beneficial to our clients and to managers to get an idea for what district court judges are saying, and when the Court of Appeals and Supreme Court agree or disagrees with them, we can get a lot of direction and apply that to serve our communities. So one of the common things that we do is update governing documents. Sometimes they're 50 years old, sometimes they're 10 or 15 years old, but we look for opportunities to improve them, to provide clarity, to take out ambiguity, to provide directions to boards and to homeowners about how the project works, what the rules of the game are. And so we keep a list of disputes we run into. We keep a list of things we can improve, and we're constantly trying to adapt and improve our governing documents to serve our communities. So I'm going to be talking a little bit about emergency powers, some procedural things like elections and open meetings, and then lastly, joint use agreements, which the COVID pandemic has brought to light certain challenges when we have joint use agreements. So real briefly, here's my checklist of some of the emergency powers that I intend to implement in governing documents as we draft them moving forward. You know, as the pandemic first hit, we had all these questions about whether collection of assessments would become more difficult if homeowners losing their jobs or losing income would no longer be able to pay the assessments. And we had a talk of emergency funding and stimulus to help boost the economy. It turns out that to date, we have not had a crisis in collections, but it's not hard to foresee a situation where we would want to draw from some of our savings or our reserves to be able to operate the association. And so one of the things I have on my list is to build in authority for a reserve account and to be able to have a process to draw from that reserve account in the face of an emergency. Next, a common question our office received is, can we just shut down the pool until we get more information about this virus? Can we just shut down the clubhouse and exercise facilities? And some governing documents had authority that we could look to and rely on, and others really didn't address that. So we had homeowners feeling frustrated that they've paid all these years, they have a joint ownership interest, and I don't get access to these common areas. So I have on my list to build into governing documents clear authority to be able to shut down common areas in the event of any kind of emergency or pandemic or epidemic where we need to, for health reasons, temporarily close the common areas and not face liability for making that tough decision. Even more common than that, we've had the question of, can we just cancel the 2020 annual meeting? Or our documents say it's supposed to be in July. We really are not ready for the new Zoom format or whatever format. Can we bump it? Give ourselves a couple months to get prepared for that. And for this reason, I'm really targeting provisions and governing documents that have a strict requirement that gives really no flexibility to be able to move the annual meeting for things like a national emergency or a pandemic. And it just makes much more sense to allow a board to have reasonable discretion to adjust the date of an annual meeting, or board meetings for that matter, to accommodate other important pressing needs like health and safety and welfare of our membership. For those that decided just to go forward with their meetings and struggle through it and hold an election, we've seen various levels of success in conducting elections. Having provisions in your documents that clearly allow for electronic balloting and electronic voting, and maybe even the option to forego a secret ballot, which is especially challenging when conducting it by Zoom, to be able to have a process whereby owners feel like they can vote in secret for their board members, including some kind of discretion to do away with that secret ballot requirement if it's just not feasible or practical for a board to facilitate it. A couple more on my list are to build in emergency budget approval. Maybe we couldn't hold that meeting, but we need to get the budget approved for next year, or maybe we need to amend the budget to account for new costs that have arisen because of an emergency or a pandemic. Some associations have looked for a safe harbor in foregoing enforcement for collections or hardships, saying, hey, I really don't want to be going after this owner right now when they just lost their job and they're dealing with illness and they lost a family member. Can we build in some discretion to consider hardships in our enforcement of our governing documents, primarily with collections? Looking to include additional provisions regarding maintenance requirements. Maybe we want to follow Scott's good advice and require some additional sanitation for use of a clubhouse. Maybe we want to restrict use of certain parts of the facilities to discourage those high touch points that Scott talked about, just to avoid the spread of a virus, a dangerous virus. And then lastly, and Quinn did a great job of hitting on these, we can all look to our governing documents to make sure that boards and managers are protected from liability in making these tough calls and balancing the competing interest of those who are eager to continue to use the facilities and those that are fearful of overuse of the facilities. Now, just a couple points of caution before we move on to the legislative update and case law update. Certain of these powers might be limited by statute. So emergency rules, we still have to follow in a community association that's not a condo. We still have to follow the rule adoption process set forth in the Community Association Act. There's not a provision to allow for emergency rulemaking. So that requires advance notice to the membership. So when we're faced with these kind of emergencies or crises situations, we have to act quickly to get new rules in place. Reserve funds, we already have a statutory provision that would allow us to use reserve funds for other uses, but it requires an owner approval. We can't just have a board making emergency decisions to dip into the reserve funds. Beware of the statutory limitations there. And then lastly, well, there's actually two more. The open meeting statute, we may not be able to close down our board meetings. We need to find new and creative ways to provide access to owners that by use of technology or use of creative social distancing ideas to allow people to come and attend and listen to the decisions that are being made by our boards. Lastly, be aware that the Nonprofit Act does require for nonprofit corporations an annual meeting to take place. So proceed with caution if you're one of those associations or your manager that's choosing just to skip an annual meeting on any given year. You may have an owner with a legitimate complaint, given that the statute requires it, and most HOAs are finding a way to get it done during the pandemic. Okay, joint use agreements. This is where we have an agreement for two separate associations to use a common clubhouse or to use a common park or a common pool. And we've seen many situations recently when these two HOAs disagree about how the pool should be handled. One wants to close it, one wants to keep it open for use by all the residents. So really, as we get into this area, we have to look to the decision-making authority in the joint use agreement itself. These decisions about how to break the tie or overcome the disagreement is really contractual. We have to look to that agreement. There's nothing statutory to help mediate these decisions. On the point of mediation, as we draft these joint use agreements, we need to do a better job of including provisions for alternative dispute resolution, so that that's what ADR stands for, is alternative dispute resolution, to avoid litigation or unnecessary fights. And we have a way to take it to the residents, or have a way to get to a binding decision when the two HOA boards disagree. I'm encouraging that you include special provisions for to be able to have special meetings or to telecommute, so that members during these times when we need their input and feedback to make a difficult decision, that we can have ways to meet with them and receive that feedback or that straw poll or binding vote. So with that, I tried to be quick. Quinn, we'll pass it back to you for the legislative update, and then I'll be prepared to do some case law.
Thanks, Tyler. There are 5 bills that we can talk about. The last one we already did cover. That's the COVID immunity. So let's look at the first one here. This is House Bill 57, and what this did, it doesn't take effect until January 1st of 2021. What it does is it changes some signing requirements of locations where parking is enforced, well, towing is enforced. And the Department of Public Safety, in the statute, it says that they should be coming up with examples of signage of what can be used. I haven't seen those yet, but they're supposed to come up with illustrations or take pictures of some of the signs that meet those statutory requirements. And then finally, the statute talks about, well, really what you want to have in any of these signs are clear instructions. And the question is, what does that mean? What are clear instructions? Statute doesn't say what clear instructions are. When you go and listen to the legislative history or the legislators talking about it during their floor debates, the best information that we could get is a quote from one of the legislators where he stated that clear instructions means someone new to the area will need to know where parking is permitted. That's still not very clear, but that's the standard you need to be looking at now, is how clear are those signs? If somebody just coming to the area, are they going to be able to figure that out? And since we're talking about towing, whoops, can you go back real quick? Let's see. Since we're talking about towing, I had a short video I wanted to show. One more back. All right, let's do this. All right, we're only going to do about 30 seconds of this, but saw this video about towing. I thought it was pretty funny.
Quinn,
All right,
I gotta laugh. I want you to know I'm laughing over here. That is priceless.
All right, go back to the slides. I thought that was great because, you know, I'm sure anybody who's ever been towed wishes they could get payback like that, right? Take the tow truck driver or the association for a ride there. So, all right, the next House bill, 155. This one, it doesn't change too much. from what associations already had, but there is a slight change. Really what it's requiring is just the when a seller is selling their lot or unit, that they have to give certain disclosures to the buyer about the governing documents, and especially those documents that are recorded with the counter recorder. And the seller can request this from the association, which managers here, you can probably already say, yeah, we've been doing that. So there's not a big change with that. The biggest change that this brings about is it states that the Department of Commerce will publish information on its website giving an overview of community association laws, and also it will talk about how an association can be disbanded or dissolved, which that's going to be difficult. And the main concern that we have from the Legislative Action Committee is what's going to be included in that informational materials. So I know we've reached out to them saying we want to help draft or at least review those materials so that we can verify that they're going to accurately represent the community association laws. So that's still forthcoming. So we look forward to seeing that, but not too big of a change for most managers. The next slide, this has to deal with some construction defects. Let's see, is it advancing? There we go. So with construction defects, what this one does is it clarifies that the 6-year statute of repose applies to include product liability claims. So, those were not in there before, so it's applying to those who provide labor and install these materials. The initial draft of the bill proposed only a 3-year statute of repose. I do have to give credit to Tyler. He and I went and met with the representative who proposed this bill, and Tyler did a really good job in helping him understand that his builder clients that he was really pushing this for could be negatively impacted by shortening that to a 3-year statute of repose, because some of the early subcontractors that may come in and do work on a building, especially if it's a larger project, then that 3 years could expire before they even really got into operating the building and recognizing that some of these defects could be there. So next one is Senate Bill 183. This is probably going to have the most immediate impact on associations. What this does is it changes part of the procedure for doing non-judicial foreclosures. So previously, you had to send notice to the owners of the association's intent to pursue a non-judicial foreclosure, and they had 15 days to demand that a judicial foreclosure be taken. Did not require that the association prove notice or prove delivery of the notice, but only that it was sent regular certified mail. If they didn't sign for it and came back, the statute just said we had to send it. That's been changed to now it requires that the notice be delivered. So the association has to be able to prove that it was delivered to the owner, and they had at least 30 days after that delivery to elect whether to demand a judicial foreclosure. So it makes it a little more onerous on the association to get those notices delivered. If you can't prove delivery, then you do have to pursue a judicial foreclosure. A couple other things that it did was it requires that any of the delinquent assessments have to be at least 180 days delinquent before you can pursue the non-judicial foreclosure. And it excludes fines from the non-judicial foreclosure process. So if there are fines that have not been paid, the association has to decide whether to just bifurcate those, pursue the remaining assessments, late fees, interest that have accrued through the non-judicial route, and then they'll have to pursue fines separately, or they pursue it all through a judicial foreclosure process. So this bill really came up for those of us in the industry. This was the senator who brought this. He actually had an experience with an association, management company, an attorney. We don't know who they are. He never named them, where they were pursuing some foreclosures against him the senator was not happy with the way the association was being operated. He didn't think that they were fulfilling their duties, so he stopped paying assessments in protest. They started the foreclosure process, and he eventually resolved it with them, but then determined that he was going to change the law to make it harder. The initial bill prohibited all associations from pursuing non-judicial foreclosures, and we were able to work with him to allow it to still proceed, but with these modifications. So again, that's probably the one that's going to have the most immediate impact, other than the COVID immunity, which was passed in the special session. We already talked about that a little bit early in the presentation. So those are the statutory updates that have already occurred. Just as a heads up, with our Legislative Action Committee, a couple of things that are on the horizon that we're looking at for next year. There is a bill we've been told it's going to be brought up where it would allow owners to install video doorbell cameras, maybe even other security cameras, and the HOA would not be able to stop them. Right now, the associations, they do have the authority to limit that if the association is responsible for the exterior maintenance of the building. But this would require the association to allow those. What it's stemming from is there was actually an individual who was murdered in an association, and there were no video cameras, and so the family they have no leads, and so what they were saying is if they would have been allowed to have some video cameras, probably wouldn't have stopped the crime from occurring, but they could have at least had some leads for the perpetrator. So that one's coming up, and then another one is also dealing with document requests and what is considered a record of the association. And so that one may be introduced this next session. I know we're still working through that. Tyler's been drafting that and trying to define what is an association, because right now we know it's a gray area as owners are requesting records. Some of these requests are very broad, and the question is, does an association have to produce everything that's requested? Is that considered a record or not? So that one, those are the two that we may be looking at for this next legislative session. We did have some others we were working on, but given the current environment, we may push those off to 2022. Okay, Tyler.
Thank you, Quinn. Super helpful. And I just want to give you a shout out too. I know we both spent some time up on the Capitol, but you particularly on that collection bill, dealing with a very difficult representative. And I speak for the industry and thanking you for all the volunteer time to help us have good legislation. So much appreciated. Okay, we had a lot of case law this year or recently to update on, and some of these cases we could really get into the weeds, and I'm going to try to just focus on the main takeaways and the interesting points that I think will be helpful for our group. This first case, Thompson v. Capener, comes out of a little HOA up in Tremont in Utah, and the outcome of this case was very surprising to me. This involves trying to bring a new home into the subdivision and bind them by the CC&Rs. So they approached the lot owners and asked them, will you please sign off and become part of our association? And in this case, they got a signature, but only from the husband and not from his wife. Then the husband and wife sold the property to a new couple who wanted to do some changes and update the property. Well, the neighbors weren't happy about the changes, so they sued him and said, you're violating the CC&Rs. The new couple said, no, we're not. They don't apply to us because they were only signed by the husband who sold it to us and not by his wife. The district court disagreed and said, no, signature by the husband is enough. We've got a deed and a plat that makes references to restrictions. You should have been on notice that there were CC&Rs here. You lose. The new owners appealed, and the Court of Appeals said, no, actually, both spouses didn't sign off on it. And the wife, there's no evidence that even though she didn't sign, that she ratified and was okay with it. So the CC&Rs do not apply to this new couple, and they are not bound by any of those restrictions. So the takeaway for us is when you're obtaining signatures of one owner and not the other, make sure that the signature block on your ballot or a signature for CC&Rs makes it clear that they have authority and are representing to sign for all the owners of the property and not just for themselves, because otherwise it may be invalid based on this Thompson v. Capener case. Okay, this case is very technical. I won't spend a lot of time on it, but I've included a little graphic here. Pioneer was the HOA, and Pioneer HOA was built on an old drive-in movie land. And the drive-in movie encroached on the two neighboring properties depicted here as Tax Hawk and Vandelay. So just to be clear, the dotted line is what the HOA actually had on its deed. The solid line is what the HOA was actually using and cut into Tax Hawk's and Vandelay's property. So there was a dispute over who gets that land. On the one hand, Pioneer only has deeded up to the dotted line, but on the other hand, they've been using it for decades up to the solid line. So there was a boundary dispute here between the HOA and these neighboring property owners. And the court basically held that even though the Pioneer HOA only received a deed up to the dotted line, that they were entitled to pursue a claim for boundary by acquiescence to take over the land that was years ago deeded to Tax Hawk's predecessor and Vandelay's predecessor. So the takeaway from this one is the HOA may have rights, depending on what their predecessor gave to them, to pursue land that they've been using, even though that it wasn't deeded to them. So this is a very technical case, but it's a good one if you have an HOA and a boundary dispute. Okay, this next one, Vanderwood v. Woodward. I actually think this case is very, very helpful to HOAs in understanding when a covenant has been abandoned and is no longer enforceable. In this case, we had a neighbor build a pole barn. They didn't build a beautiful garage with hardy board siding or brick or some aesthetically pleasing exterior finish. Instead, they just went budget, efficient. They put up metal poles with metal siding and built a little pole barn as a detached garage. The neighbors lost their minds. It was ruining the neighborhood, ruining their lives. So they brought a lawsuit saying, you violated the CC&Rs. The pole barn violator, alleged violator, defended the case saying, well, wait a second. You have abandoned your requirement to get advanced approval because you have not required other owners in the neighborhood for years to get advanced approval. And they pointed out all the homes in the neighborhood where those owners did not get approval before they built something. They also said, hey, you're trying to apply the covenants for dwellings to my garage. And the CC&Rs say that these restrictions on exterior surfaces and finishes only apply to houses, not to garages. The court agreed with the pole barn violator and said, yep, the HOA had waived its requirement to get advance approval by not doing it for years on end. And they also said that although all the CC&Rs were not abandoned, we analyzed the building material covenant to apply only to dwellings, not to garages. So there's a couple takeaways here I've included in the slide. Abandonment of a covenant occurs when there's a substantial and general noncompliance with the covenant. So having an aberration here or there or some noncompliance here or there is not enough. It's got to be substantial and general noncompliance. The court goes on to say if it's slight, unimportant, unsubstantial, or minor, then you haven't abandoned or waived your right to enforce them. So I feel like we get some helpful guidance here about when something has been waived and we no longer have the right to enforce it. Okay. Timber Lakes, lessons learned in this case. At the Timber Lakes, an owner, again, built a garage. And the location where they built their garage was in an area of the association that Timberlakes wanted potentially in the future to locate a road. They did not have definitive plans, but thought, hey, maybe in the future we will expand or put a roadway here. Well, when the neighbor put up their garage, it cut off that opportunity. So the HOA brought a lawsuit against the garage violator saying, you've ruined our opportunity to put in a road in the future, and we want an order that your garage be taken down. Ultimately, the Court of Appeals says, no, that order cannot be granted because you do not meet the requirements of a permanent injunction, particularly the requirement that you show irreparable harm by placement of the garage. The court said, because you did not have definitive plans to put the road there, it was just a hypothetical plan, you cannot prove that you were irreparably harmed. And because in your lawsuit, you did not sue for money damages for the extra cost to relocate the road somewhere else, it's too late now. So the takeaway for an HOA is, if you have any doubt that you're not going to be able to show irreparable harm in your lawsuit, make sure you include your claim for money damages for the increased costs of the violation. Because if the court disagrees that you are harmed forever, you might be cut off in your ability to have it taken down and your ability to recover the additional cost to relocate your road or whatever it is in that particular case. Okay, Bell Canyon Acres v. McClelland. This is an HOA in Utah that had bridle paths for equestrian use, horse use, basically a path for horses to ride on with the residences. I like the opening of this case. The opening line was, good fences, it appears, stop making good neighbors, right about where they start to encroach on the bridle paths. So here we have some owners that built some fences onto the HOA's horse paths. And the HOA brought a lawsuit to tell them you need to move your fence. But in this case, they only sued 4 of the encroaching owners and not many of the others that were encroaching. The defendants in the case, and we see this commonly, said, hey, HOA, you don't get to do that. You have to sue everyone in the association. You have to name everyone because the outcome of this lawsuit will impact all of the owners. The court actually disagreed. The court said, no, we don't think they have to bring everyone into this fight. They are entitled to bring only those owners that they choose. But the ruling that we issue will only apply to the owners that have been named. And if you want to have that case have any binding effect on other owners, it will not. You will need to sue them separately, and their rights may be determined separately. So it's a common issue that comes up as to whether we need to name everyone in the association. This case gives us some direction about whether we need to or not, and in this case, they did not. All right, this may sound familiar to some of you because it involves one of our sponsors and local management companies. This is a case in Harriman where an owner sued for an injury by tripping on a metal rod that was protruding from a park strip. Now, in this case, the park strip was not HOA land. It was Harriman City land. But the HOA, this owner or resident was crossing over the park strip, tripped and injured their leg on the metal rod protruding out of the park strip. The owner initially sued the city because it was their land, the HOA, the HOA's management company, all 3 saying you are liable for not protecting me from this metal rod in the city park strip. The district court said, no, you don't get to name the HOA as a defendant, and you don't get to name the management company as a defendant because you don't have evidence that they were aware of the risk and failed to act. The Court of Appeals analyzed the evidence a little differently and said, no, we're going to allow you a shot at trying to sue the management company and the HOA because even though the HOA and the management company do not own the park strip, they have a duty to maintain it by city ordinance. And the city ordinance in Harriman is that HOAs are responsible for adjoining city sidewalks and park strips to keep them clear and free of obstructions and dangerous conditions. So in that case, the owner was entitled to go back and have a shot in their day in court to sue a manager, an HOA, and the city for failure to keep a city park strip free of dangers, in this case, a metal rod. So I think that's, oh, one last case. This case involves an association in Harriman that was created back in the 70s, High Country, but Phase 2. High Country 1 has been the source of a lot of case law that's been beneficial for our HOAs. Now we're getting some benefit from High Country Phase 2. In this case, the owner sued saying these CC&Rs back in the 70s were invalidly adopted and we should not be bound by the covenants here in 2019 or 2017, whenever this case started. The district court judge said, no, you're too late. This community was created back in the 70s. You're barred by the statute of limitations. There was argument about whether this certain kind of lawsuit called a quiet title meant to eliminate encumbrances on your property like CC&Rs or other deeds. There was argument about whether that law entitled them to bring a lawsuit regardless of the timing. They said we are never barred by a statute of limitations, and the Court of Appeals, and actually in this case the Supreme Court, agreed that if pled rightly in a complaint and in a lawsuit, an owner is never barred by a statute of limitations from challenging the validity of CC&Rs. In this case, even when it was roughly 50 years old, they were still allowed to bring a claim. And that litigation is not completely resolved. There are still other questions that need to be decided about whether those CC&Rs are void or voidable by those owners. But the takeaway is you may never be safe from on a statute of limitations basis from a challenge on the validity of CC&Rs. And that concludes the quick case law update.
All right, we'll just allow another minute or two. If there's any other questions, feel free to type them in the chat box and we'll get them over to Tyler and Quinn. But thank you so much, you two, and Scott, for presenting. That was very informative and helpful.